Hello and welcome to ProTrust Consulting. I'm Rob Cartmell, and this is just a briefing note regarding lasting powers of attorney, a very important element of our estate planning service. This will be about 10 minutes long, just a quick summary of the previous law of enduring power of attorney, how that changed then in 2007 to lasting powers of attorney, and then just the scope of LPAs and what they mean, why people do them, and the sort of things that should be thought about when preparing them. So let's have a look at the law that used to apply. Back in the olden days, we used to have something called enduring powers of attorney, and that's how that form looked. So if you've got one of those in your possession, they are still valid documents. They apply relating to financial matters only, not health and care decisions. You'll see here an example version where one has been registered in 2016. Registration then was required when someone began to lose capacity, and there was a process where you had to reply to register them at that point. Now, government changed the scope of LPAs under something called the Mental Capacity Act in 2005, and that created a new style called a lasting power of attorney, and that's how one of these looks, if you can see that on the screen. This relates to property and financial affairs, and what I plan to do is just have a quick run through of these forms and just sort of tell you some of the important factors to deal with them. So let's have a look at one of the lasting powers of attorney. Here's a financial one. 1 second. There we are. This is an LPA for financial decisions. So people do these for running bank and savings accounts, making and selling investments, paying bills, buying or selling property. They do not extend to matters of creating trusts, or usually they don't extend to acting on behalf of directorships in companies, and they don't apply to making changes to your will. They are active as soon as this document is registered by the Office of the Public Guardian. So when we're preparing them, we then make sure that they're registered so that they're available to use when required. Now, the key element of this document is that it applies now. If you sign off a lasting power of attorney, it can be active whilst you have mental capacity. And if you lose mental capacity, it continues to operate, it lasts. So these forms are 24 pages long. We take you through each element in some detail. The person creating the power of attorney is called the donor. Their attorneys are usually people they are closest to, so spouses, children, best friends. An attorney is not a legal attorney as such, like a lawyer. It's someone who will make decisions for the donor. You need at least one, but you can have more, and you can choose replacement attorneys. So this is a major change from the enduring powers of attorney in 2007, where you couldn't appoint substitute attorneys. And the details are all mapped out in the form. There's a couple of important elements here. If you appoint joint attorneys, so you might appoint your spouse and your eldest child, for example, you can decide whether the decisions are made on a joint and several basis, which is saying that each attorney can individually decide for you or together. And most people do choose that because it's the most practical option. And the other alternative is to appoint attorneys jointly, where every decision is unanimous, however big or small. Most of the time you will see people ticking or selecting this box, joint and several, because it is the most flexible. And there's another aspect to this I just want to highlight, is that you can then select with the financial power of attorney when your attorneys are allowed to take decisions. Most people make them active instantly that they are registered, and also when they don't have mental capacity. most people choose this because it is the most practical and flexible option. While you've got mental capacity, your attorneys can only act with your consent. But the important thing is as well that if you later lose capacity, they can continue to act on your behalf for all decisions. So I found that with various situations, this is useful. I have had a situation specifically where a client has gone on holiday having signed off a contract and it needed to be amended and re-signed, and they were away. So their attorney under this power could actually deal with that for them. So it is very helpful for people who are away, or in particular who do not suffer mental incapacity, but who later in life, say, develop a physical condition. So a condition that makes it difficult to visit the bank or talk on the phone or execute documents. So for my father, my late father, when he had Parkinson's, he was very much unable to visit the bank and undertake documents, although he retained mental capacity. Having his LPA in place, selecting it to be available to be used at any point and when he didn't have mental capacity was really helpful. But you can limit it to only when you have only if you lose mental capacity, which can make it a lot less useful. So that's some of the elements to deal with financial powers of attorney. Other sections here are quite useful to consider whether you give some preferences or options. I think it's certainly helpful where clients have a financial advisor advising as to investments, that you do give specific instructions for discretionary fund management to be maintained. And there's some specific requirements there that are useful to put in as instructions, which I will take you through when I see a client to deal with financial powers of attorney. Also, it's very helpful to give some specific directions. So if you did want to use your financial advisor who's known all your matters and and your finances, and you want to give some directions to your attorneys to use your financial advisors, for example, then that can be helpful to put in as preferences. Also, I'll mention a couple of others when we have a look at the health one, which I'll just go to now, because this is just a brief note on these things. The other type of power of attorney is for health and care. Now, this only applies for circumstances where you have lost mental capacity. And it's a very important document to have this in place as well for healthcare and medical treatment you receive, including life-sustaining treatment. It could be decisions about where you live, whether care is provided at home or in a home, and day-to-day matters such as diet and daily routine. So very much a similar format where you choose your attorneys in the same way. And I'm just scrolling down here because there is a specific section in here to deal with preferences and instructions. And I think it's important to include some details to allow consent for medical records to be released relating to yourself, because they're obviously private data and otherwise might not be available to your attorneys. So important to have a specific preference in there. And as well, so I'll just scroll back up. There's one other section I meant to cover there, which is life-sustaining treatment. And there's a specific section that covers this. And when I take you through this, you'll see that the government, the OPG, are quite flexible and aren't too prescriptive in how they define mental incapacity and the process of life-sustaining treatment. There's a nice explanation in this document, which I would take you through, but life-sustaining treatment means care, surgery, or medicine to keep you alive. Could be a serious operation, cancer treatment. And really, this form is to give authority to your attorneys to take decisions on your behalf. And it says here, if you select here, your attorneys can speak to doctors on your behalf as if they were you. Whereas the other option is that you don't give your attorneys authority to give or refuse consent to life-sustaining treatment on your behalf. And you'll see the shift from attorneys to doctors. If you choose this option, your doctors will take into account the views of attorneys and people interested in your welfare, as well as any written statement you have made where it is practical and appropriate in the eyes of the doctors to do so. So that specific question is a part of a lasting power of attorney for health, and it's an important one to talk through in proper detail. There's some other aspects of a lasting power of attorney, which I'll just skip to here, which are the important legal rights and responsibilities. There's a good little section here that the LPAs are governed by the Mental Capacity Act, and there is government guidance at the gov.uk website, which is very helpful. The main principles centre around your attorneys acting in your best interests. And there is some useful guidance on this form, which I will take you through. And before you use it, it must be registered. So we have to register that for you. Well, that's our recommendation, certainly. Otherwise, it might just sit there, and then the registration process takes a few months to be completed. So you don't want to be doing that registration process at the last minute if you've suddenly had an illness or other incapacity has arisen. Once you've done a lasting power of attorney, it doesn't crystallize it forever. If you want to change it, so you can cancel it. So if you fell out with your attorneys, or you wanted to add another attorney or change the attorneys, then you can do that. You can cancel the LPA and redo a new one at any time, as long as you've got mental capacity to do so. So even the registration process doesn't affect that. And this is where this goes then hand in hand with wills and trusts discussions. Your attorneys cannot use this to change your will, and it does expire on death. So your attorneys act for you during your lifetime, and then on death, your executors look after your estate, your funeral, and then your estate assets and how they are distributed to your beneficiaries. So that's how it links up. And there's an important set of signing parts to the LPA process, which I would, of course, take you through. And your attorneys must agree to act and sign the forms and understand. So definitely part of our process is to take you through this as a donor and your attorneys. So very much it's involving the family. A Teams call, a Zoom call can be a very useful way of getting everybody together, looking at a document on screen and taking you through it. And I hope this is a helpful brief rundown of the uses of lasting powers of attorney. And the last thing to say is, if you don't have one, it's not the end of the world. There is a process if you've lost capacity, and that is to apply to the Court of Protection. And the Court of Protection is an excellent system where the court oversees the running of your health and finances, where they monitor the deputy who's appointed. So instead of an attorney, there's a court-appointed deputy, but the process takes a long time to make to court, and it's expensive, normally a couple of £1,000 at least of cost, and further time in reporting back to the office of the Public Guardian or the Court of Protection. Whereas an LPA, once it's been approved by the Office of the Public Guardian, the attorneys have the authority to act. There's no further involvement with the Office of the Public Guardian unless there's some problem that arises. So absolutely best advice is to get them done, get both done, and while you're in good health, not desperate last hours when you are facing the situation of losing capacity. That can be a very distressful time. So get them done while you're in good health and in good capacity. So I hope this is helpful. Please come and see us at ProTrust for any further advice on this subject. Thank you.